recording. Mustn't forget that. Okay, so this is Laws 13013, Legal Professional Conduct, Module 7. This is looking at communication and control. And we've got problems 28 through to 31 to have a look at. Okay, so we'll just zip over to the Safari site for the course for the minute. I just wanted to draw your attention to this client interviewing exercise that's coming up. Margaret, I might just get you to mute your microphone for a second. Oh. That's okay. Thanks very much. Just a little bit of background noise coming through there. Just in terms of this client interviewing exercise, I just want to explain to you how this will work. Now, this is coming up on two sets of dates. On the 12th and the 13th of May, that's when I'm hoping that you'll do your exercise, and I'll be posting the exercise details up on I'll be actually emailing them out to students on the 12th of May at about 9 o'clock in the morning. Before then, you need to see if you can get yourself into groups of 3. I sent an email out today to everybody explaining what the process is, but if you can self-select into groups of 3, I'll have a look at what the result of that will be on the 5th of May, and if I find that people are having difficulty getting into a group, I'll then assign the people who haven't already gotten themselves into a group for the exercise. So if you form a group, I just need to know the name and student number of the people in the group, because there's 3 exercises and each student in the group gets a different set of facts for each, or 2 of the students in that group get a different set of facts in the exercise, and you're going to do 3 of them, and from that you will take on the role of an observer in at least one of those 3 exercises, and you'll write a note on what you like a reflection of what you observed in terms of the interview process itself, and then you'll play the role of the person doing interview in another exercise, and then you'll play the role of the person being interviewed. So because there's 3 people in the group and there's 3 distinct exercises, in each exercise you occupy each of the roles. So that's the idea. But you're actually marked on what you observe in that role of an observer. But what I want to happen is that you do the exercise on the 12th and 13th of May, and then you basically have a week or so, you have till the 23rd of May to actually write up your reflection. So that's sort of how it works. Are there any questions about that exercise? As I say, I sent an email out today just explaining it a little bit more detail about how it works, but that's the gist of it. Has anybody got any problems or confusion or issues about that? Okay. Good. Yep, go on.
To be recorded by Zoom, how do we go about that? Do we need to get numbers or...
what you'll do, what I suggest you do is that you get a free license for Zoom. You've already got one to be able to view it. And in Zoom itself, you can run the Zoom session yourself. You can set up a Zoom session, and then it's got a little record button. So if you're the observer, you'll record the Zoom session with that all 3 students are participating in. Now what happens is that when you then close the meeting, Zoom will actually create an MP4 file and put that on your desktop of your computer. Now, the reason why I'm asking the observer to record it is that you then got a record for you to go back and have a look at when you're writing your reflection. Now, if you don't want to record it, you think you can write up your reflection just on seeing what happened, that's fine. I just think it's good if you actually make a recording that you can then refer back to, that's all. It's quite easy to do. I might have to make a little film just showing you how to do it, if that'll help. So I might just make a little note about that. So you really want a training training film on Zoom. So I'll send that out. The best way to do it is just to experiment with Zoom. You can record yourself. You can just create a Zoom session and it'll record you, and then you can close it, and then you'll see how the recording is put on your desktop. So I suppose what I'm saying is have a go at it. It's not too hard to do, and I don't think you'll have a problem with it. Okay, other questions about that piece of assessment? No? Okay. I'm about halfway through marking the assignments. People have done really well on the assignments. I'm really happy. I think you'll be pleasantly surprised too. A lot of creative people out there. There was some very interesting little scripts and scenarios came out of it, and people have put in the effort and done a good job. So I should get those back to you probably by Monday. I'd say next week. I'll just send them all out then, I think. It's taken me a bit of time to mark them because it's a bit different from where you set the same assignment for everybody, and you've got, you prepare an answer guide and then you can easily mark things. You can do it fairly quickly. But when they're all different and they're all dealing with different issues, it does take a lot more time because you've got to have a broad knowledge of the actual discipline to be able to mark those things. So that's why it's taken me a bit longer than I normally would take. But I'm getting there. But as I say, they're pretty good. Okay, all right. Well, what we've got this week is 4 problems. So I thought we might start and have a look at those. So problem 28 basically says that your client has been married for 25 years. There is one child from the marriage who is 24 and happily married. Your client is now 43 and feels that she's missed out on all the fun of adventure and travel. She's just left her husband and intends to have a simple life for several years in places like Indonesia, India, and Nepal. She hopes to find herself. Her husband is very, very willing to support her new life as long as she signs a property settlement, which leaves him the family home worth 1.2 million, all the other assets and investments worth 600,000, and promises not to make any future claim over his superannuation. He is a professor of law. Well, there's the first problem. He should never have married a professor of law. Anyway, and he'll retire in about 5 years, and he's offered her a settlement of 200,000. It's quite lousy, isn't he? So he gets all those assets and superannuation and what have you, and she gets 200,000 in cash. Your client feels guilty about leaving and believes that 200,000 could last her for several years in which she wants to wander and find herself. Living in meditation centres cost very little. However, she would be entitled to a substantial property and maintenance settlement. When she and her husband married, she became pregnant and decided not to pursue any studies. She focused her life on bringing up the children, supporting the husband's career. Thus, she has not worked throughout the marriage, has no credentials, no future prospects for a decent, financially rewarding employment. She's instructed you not to ask for too much more than the offer of 200,000 because, in her words, I know if anything happens to me, he'll always provide for me. If I ask for too much money, he may get upset and I will lose his goodwill in the future. What advice can you give? Well, what do you think about that situation? What do you think? Who's going to have a go at that? Don't all leap up at once. Christine, you haven't got your microphone muted. That's a bad sign. What do you think? Can you make it?
Oh, no, I didn't even realise it wasn't muted. Oh, no. Long day. You'd have to tell her that obviously they're going to be, she could claim more than what she's obviously going to ask for. And when she says that he's going to give her goodwill in the future, you have to advise her that, she's settling for this and she doesn't have any claim on his estate anymore in the future. So you'd tell her to go back and do it properly.
Okay, yeah. How would you tell her? Would you do it in writing? Would you say it to her? How would you tell her? You're saying tell her, but how are you going to tell her?
Well, you'd have to first. Just to be nice, I'd probably give her a call first and say, look, it's probably best you come in and see me face to face, and then you do a face to face meeting. But you'd also have to back it up in writing, because that would also comply with Lexon Insurance, with all your professional indemnity insurance, to be able to say, look, we gave you this advice on this and this date. You came in and had a meeting with our solicitor, blah, blah, blah. And this is the advice we gave you. Because she'd probably have to sign also, or she'd have to get a legal solicitor's advice. Sorry, it's been a long day. She'd have to get independent legal advice to be able to say that she was advised on what she could claim, but she's only wanting to claim this.
Oh,
Does that
okay.
make
Well,
sense?
Luke, actually, stop there. Luke, do you agree with that? Does she have to get another independent legal advice?
No, I would think not. If you're instructing this particular client, where does it end? Where is it sufficient to say, oh, well, you've got to get advice on my advice on my advice? I would think that you can instruct her to say, look, I think you should not accept this particular settlement for these particular reasons. That would be placed in writing. However, you'd be obliged to follow her instructions if that's what she wished to take on.
Yeah, I think that's right, Christine. I think your answer was fine, apart from the bit at the end about having to get another set of legal advice. I mean, perhaps.
Yeah, sorry, I was wrong. Yeah, sorry, I was wrong. I know it'd be if you're acting for the husband, you'd have to tell the wife she needs independent legal advice, and they'd have to sign a certificate off on that, I think.
Yeah, that's what I was going to ask Margaret. You're lucky there, Margaret. I was going to say, what sort of circumstances would you actually suggest that the wife get separate legal advice? And the classic one would have been if both of them had turned up, if the husband and the wife had turned up together. In this sort of situation, you wouldn't want to act for both parties because there's obviously a conflict in their positions, and it's certainly very unfavourable in terms of the position of the wife here. Margaret, I could ask you what do the solicitors' conduct rules say about this sort of stuff? What are the general duties that apply?
Well, yeah, in the answer to this, I did look at Rule 7, 7.1, I think, and 7.2 around giving advice, clear and relevant legal advice, and also putting any alternatives to her. But then I said following that, there was Rule 8, which is where the solicitor acts on the instructions of the client.
Yeah,
and regardless of whether you think the client's getting a raw deal or not, if you've given that advice to them and they've made a decision about which way they're going to go and they instruct you that's the way they wish the matter to be run, that's what you do.
Exactly. So that's fine. The other one you probably should mention as well is in Rule 4. There's provisions there that in 4.1.1 that the solicitor has to act in the best interests of the client in any matter. So, and they have to also in 4.1.3 deliver legal services competently and diligently. So what that's going to mean here is that firstly, as a solicitor, you would recognise that this client is really in an unfavourable position. They're being offered unfavourable settlement, but also they're at a disadvantage because of the the legal knowledge, if you like, of the husband, but also that they're a disadvantage emotionally. So one of the things which is probably a bit of a grey area is that you might want to think advising the client as to whether they actually need to see somebody like a psychologist to get some professional help, because they're not making necessarily rational decisions. They might be in the so-called midlife crisis situation. So that might be something to consider. But it's a very delicate matter to say to a client, isn't it? That you think that they need some professional help in a different capacity other than what they're seeing you for. But in terms of the advice that you give them, you can certainly discuss it with them. It's probably better to do it in person or over the phone, but you must also write a letter that confirms the content of your advice. So basically, you need to tell them that in your professional view, that the settlement proposal is unjust and unfair, and that they would be entitled to a substantial property settlement, probably including a share of the husband's superannuation, and certainly the family home and some of these other assets as well. And you would probably give an estimate as to what you thought she'd be reasonably entitled to. You'd have to advise her of the effect and the consequences of her accepting a settlement at a lower amount, and the difficulties that she would face if she tried to unpack that at a later date. She probably couldn't. And you might, basically you're then in a position after having done all of that if the client still refuses to accept your advice, then you would really want to get written instructions from her confirming that she had received the letter that you've advised her of all of this, and that she nevertheless wants you to proceed to accept the settlement offer on her behalf. In that way you cover all the bases about what you need to do. Yeah, go on. Sorry, I cut you off.
Could if you're talking about possible referrals for psychological assistance, also could you provide some advice or a referral to some financial planning people?
It could be. Well, that certainly could be another. I didn't think of that, but that's probably a good idea as well. That's not advice that you would give, and that's one of the things that, if you haven't seen that already in the course, we will be seeing is that solicitors shouldn't be giving financial advice. They should be referring, as you've said, the client off to a financial advisor, particularly given that you recognise that she's got some emotional issues, and that even if she accepts the settlement or she goes for the larger sum, she's still got to be able to manage that money, and she probably needs some help in doing that. But that help doesn't come from you, only the advice to get some help. Okay, no, I think that's good. So that, I think, pretty much covers all the issues in that question. Were there any other questions? Does anybody have another question about that? No? Okay, well, we'll now then move on to problem 29. So I'll just skip down here. Actually, I can just read it out over here. So problem 29 was that Mr. Jones is 48 and has instituted a $1.5 million lawsuit, approximately half of the value of the relevant estate, contesting his father's will. Jones was born out of wedlock, and his father knew about him throughout his life but refused to have anything to do with Jones or his mother, who died 10 years ago. Okay, so he's got this sort of strange sort of relationship with his father. He did acknowledge that the father did acknowledge that Jones was his son. There was no other surviving children, but there are 3 surviving nieces who were close to the deceased throughout his life. The will, which was drawn up just before the father died, leaves $100,000 to Jones, the rest of the estate to the nieces. Jones feels that the nieces unfairly influenced his father, that he was confused about the will's content when he signed it. Jones is very bitter about his life, currently lives wherever he can. He's on welfare, has no real skills. Basically, it can be said he's no home, no furniture, no family, no friends, no job. So he's not in a good way. He feels that his father owes him, and that contesting the will is the only way of getting out of poverty. The executor, with the agreement of the nieces, has offered $250,000 in settlement. You believe that if you go to trial, there's only about a 20% chance of having the will set aside. Therefore, in all likelihood, Jones will lose. Every time you attempt to explain your professional evaluation of the case, Jones refuses to listen. His only concern he's focusing on what his father owes him. He's very emotional, and he's saying that bastard ruined my life and my mother's. What should you do? Okay. What if you go to court and lose, and Jones has to pay out $80,000 from the will plus $20,000 for your fees? Given that he only was given $100,000 under the will, basically he would get nothing. He then refuses to pay you and has lodged a complaint with your professional association that you wrongly advised him in not making him take the $250,000 offer. What would your response be? So there you have it. You've got a whole scenario laid out for you there. Where firstly you have to deal with this client But how do you deal with this client in a way that protects yourself, knowing, because we're giving you the future, what's going to happen when it all goes wrong, which it looks like happens. Okay, so how do you protect yourself as a solicitor when dealing with a client who's not interested in taking your advice and is hell-bent on blaming you for the poor outcome that you predicted in the first place? So it's all about your duty. You know, is there a duty to obey your client's instructions? How does that fit with a duty to give competent advice? And how do you protect yourself? Okay, well, what do you think? How do we deal with this client?
I just think one of the first things you do is make sure that everything is in writing and signed off by the client. But it's certainly not an easy one.
No, it's not, is it? That's right. So it's similar to the extent of the last one, except, well, I suppose both of these clients really are difficult, aren't they? They're both difficult. They've both got emotional issues. This second one is particularly problematic as well. So what are you going to put in the letter to this client? What are the things that need to be there? What about you, Luke? What do you think?
Firstly, you're going to say that we've got a settlement offer for $250,000, which, in my opinion, would be a satisfactory outcome, given the chances of success in going forward to trial, and certainly outline the increase in the costs associated with the trial. That's going to be brief of counsel or a significant period in court. There's going to be excess costs as well over and above what would be in the settlement offer. And I would also then come back, I suppose, if his instructions were to reject the offer and play on.
Have any of you done civil procedure yet? No?
No.
When you do civil procedure, there's rules in relation to settlement offers, and if they're made under the rules of court, so if it's a settlement offer that falls within the Uniform Civil Procedure rules, if you make an offer and then basically you win, and the other side should have taken your offer because they lost and they didn't recover as much or didn't recover anything, basically, you can have situations where the other side has to actually pay more costs. So there's a whole, and you'll see this when you do the subject, when you do the civil procedure subject, there's a whole game. There's a lot of gamesmanship around settlement offers. The rules are designed to try and encourage people to make settlement offers to avoid litigation, because litigation is terribly expensive and it clogs up the court system, and usually it produces a winner and a loser, whereas settlements you can hopefully try and create win-win type situations, so at least you have some measure of all the parties getting something out of solving the dispute, rather than the litigation, which always tends to have a winner and a loser. So there's those sorts of games that people play. Here, you'd have to warn this particular person, Jones, that, in all likelihood they're going to lose. There's a strong possibility that not only do they have to pay their costs, but they're going to have to pay the costs of the other side as well. Probably it's another case like the previous one where Jones needs some counselling. You've got to recognise that he's a vulnerable client. That really another option for him would be to make a counteroffer. If he wasn't happy with the $250,000, he could have a situation where he makes a counteroffer. Maybe he'd be happy with $300,000, for example. Maybe the nieces would be happy to settle for that. So there's a possibility of further negotiations there. You'd certainly perhaps want to ask him what would he want in terms of a settlement, because maybe you can, in fact, achieve a settlement rather than going down the path of litigation entirely. But your advice would need to outline various scenarios. So it's not just limited to, you don't have a great chance or likelihood of winning, therefore we think you should take the settlement offer. It could go further than that and talk about counter offers and potential cost implications and what those other scenarios and things might entail. So that's the sort of items. The Queensland Law Society also has a guide to client care, communication and service. I don't know if you've seen that. I'll put that up with the suggested solutions for this problem, the link to that, so that you can have a look at that. But it does go through and talk about these sorts of issues that I've been raising. We haven't talked about, for example, cost agreements and complete disclosure as to costs. You'd need to do that for both this problem and the client in the last problem as well. But essentially, if the client, having got all of that advice, still chooses to ignore it and insists on proceeding to trial, what's your position? Do you take the matter on to trial? Or do you bail out and say, well, this person's not listening to me, therefore I'm not going to represent them anymore? What do you think? I mean, you've protected yourself, haven't you? You've done all the things that you need to do in terms of protecting your position. But if the client nevertheless wants to go down the path to litigation, in full knowledge of all of the advice that has been given, would you go and proceed to do that? What do you think? What do you think, Louise? You've gone quiet again.
I'm thinking no, but then I know you're going to ask me why I'm thinking no.
I'm really going to ask you why, because, is it really a problem? You've given all the advice. You're in the business of providing legal services. You've acted professionally, and yet the client is still advising you to proceed to litigation. I mean, they still have a chance of winning. It's not as if there's no chance. Is it something that you would then pursue? Well, you all think I'm asking a trick question. Is that the problem?
No, I would actually say yes. I mean, I'm dumb enough. I'd probably go, fine, let's go to court. But I'd have to get some acknowledgement from him saying, yes, I understand you're giving me this advice, blah, 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 so that when it comes back from the Legal Professional Association saying I did the wrong thing, I could say, well, no, actually I advised a client like this, but he still wished to proceed. But then this leads on to next week's stuff with the hopeless case, which I was reading about. Yeah, and I have to ask,
What you've said so far is exactly right. That's exactly what you do. So that does lead on to the next week's stuff. Is it a hopeless case? It's not an entirely hopeless case. I mean, it doesn't have a high probability of success, but nevertheless, it's entirely hopeless. So,
can I just go off track here just for 5 minutes with the hopeless case? Sorry to the other students. I was just reading about it and I was really curious, and it was a question I wanted to ask you, sir. How do you know if it's a hopeless case? I mean, if you had a look at Donahue and Stevenson, the snail bottle in the beer, in the ginger beer, how many solicitors did Mrs. Stevenson see when they said that was a hopeless case, and yet it's changed law? I mean, that's what scares me. I mean, obviously, if it's, some pensioner wanting to sue the government for making the retirement age of 70 instead of 65, you'll go, mate, you don't have enough funds in my trust account, so don't worry about it. But how do you know when it's a hopeless case? What happens if there's that split chance?
That's a really good question, because you're right. In those situations like Donahue and Stevenson and some of those cases that really turned the law on its head, most solicitors and probably even barristers looking at that case would have said, given the long precedents that existed before that was a hopeless case. So you are right in that sense. How do you know? In the one we've got in front of us now, it's easy because you're told that it's not hopeless. But what will happen in reality is that from your own experience and the experience of the other people in the firm that you work for, and the barristers and what have you that you can consult with, you'll form a view as to whether you think there are reasonable prospects of success in the matter. It doesn't have to be a situation where even if it's even if it's less than 50%, it still may not be a hopeless case. It's really where it's almost pretty much a foregone conclusion that you're going to lose. And I don't think you can put a percentage on any of this. It really comes down to whether it's arguable and whether there's a chance of succeeding. And that's probably as best you can put it. But I mean, if you're in a situation where you're consulting, getting opinions from barristers about the particular matter, and they're coming back and saying, this shouldn't be run, this needs to be settled, that there's no real prospects of success here, then that will be definitely a hopeless case situation. And then you should be trying to settle it the best way you can. But if there's an arguable case, then, even if it's got low chances of success, when you first look at it, it could be a Donoghue and Stevenson sort of situation where you get a judgment that reverses the previous law. It just depends on there's so many variables in that scenario. That's the problem. It depends on the precedents in the past, whether whether you can distinguish them now because, society's changed. The world's got a different view on these things. This new technology changed the situation, etc. They're the sorts of things that you have to weigh up in making that assessment. And it's not easy if you get one of those sort of cases. So that's probably I don't know if that's a very effective answer, because it's really a very difficult question that you have to look at on each case-by-case basis. This problem we've got in front of us now is not quite that situation. Okay, well, we'll look at that again next week. We've got a problem that looks at that sort of situation as well. Okay, any other questions about that particular problem, 29? No? Okay, all right, well, let's go on to 30. So problem 30 then, what if your client wanted you to vigorously cross-examine an important witness, a police detective who testifies that your client bribed him to avoid being arrested for possession of stolen goods? Your client says that she is innocent and did not know that the goods were stolen. In reality, the detective was bribed by X, who sold your client the goods. X is also a witness for the prosecution, has been offered immunity for his testimony. You listen to your client, but during the trial decide to be lenient with the detective because you believe that it's in your client's interest. Your client is convicted and is angry with you for not following her advice. The truth is later revealed and your client, using a different counsel, wins an appeal on grounds of miscarriage of justice. She has now complained to the disciplinary authorities. What are the arguments for and against your actions? So, okay. So what's this problem all about? What do you think, Margaret? What are the questions for this?
Yeah, I sort of had a bit of difficulty with this one. In the first instance, the client's saying they want the cross-examination to happen, and if you're acting on your client's instructions. But then when I looked at it, and if the detective's giving evidence that could be, to me, prejudicial against the client, as to whose version would be believed, and that's why I was thinking. Well, maybe that's why the solicitor didn't take that track.
Let's go a little bit higher level of abstraction. If you go a bit higher, looking at the overall questions, what do you think? So you're delving into the detail, which is okay. Nothing wrong with any of that. But if you just go a little bit higher, maybe Luke or Louise can suggest what the key issues are. What are we looking at here?
I'm actually just trying to look at the question again, Stephen, because I didn't do this one, so I'm just trying to find it to look at it.
Okay, what about you, Luke? What do you think?
Stephen, I'd say it's how the barrister has run the case for his client. So, yes, does he have to act to those instructions?
Okay, that's one. Okay, that's one
make
key
his own
thing.
judgment independently.
Yeah. Consideration of the duty of following client instructions as opposed to professional judgment in the conduct of a case. That's one key issue. Okay. And another one is the lawyer, who has control? Is it the lawyer controlling the matter, or is it the client has control? Remember, this week was about, control, communication and control. So who has control in these sorts of situations? So, so let's have a look at this. What are the duties of the solicitor? Because there's both a solicitor and barrister in this scenario. So let's just look at the solicitor first. What is their duty to the client and also to the due administration of justice? And how do those things balance out? So what's their obligation? Which is paramount? Duty to the court and the administration of justice, or duty to the client?
It's duty to the court. You've got to put your duty to the court over your duty to the client, which that was actually part of my assignment, because I was really interested as to how far that duty could extend. So in this case, the solicitor has a duty to the court not to mislead or deceive the court, and has to follow the client's instructions. But then this is a really iffy one over who's got control. Is the solicitor just the mouthpiece, which the rules, and I can't remember which one it was off the top of my head, they can't just be a mouthpiece for the client and their instructions. They actually have to do the job properly, I guess you could say. But when they're running a case through the court, the barrister, I know, can't be sued for how they run the case.
Okay, that's right. They can't be sued for negligence in running their case. Sounds like your microphone's a bit scratchy there for a minute.
Oh, sorry.
Oh, okay. All right. Well, okay. So what I'll do, I'll just stop sharing, just switch over to this other document that I've got here. Okay, so there we are. So, so if you look at Solicitors Rule 3, paramount duty to the court and administration of justice, so that's where that duty is coming from. The solicitor's duty to the court, the administration of justice, is paramount and prevails over the extent of any inconsistency with any other duty. So that's the dominant position. So then if you have a look in Rule 4, it talks about the other fundamental ethical duties: act in the best interests of the client, be honest, deliver services competently. Okay? So, but the point is that this duty in 3, the paramount duty, is to the court. Okay, what you should notice is that there is only a duty really to act honestly and with competence and diligence in the serving of the best interests of the client. There isn't a duty to blindly comply with the client's instructions. It doesn't say that anywhere. So if the client is telling you to do something that's not in their best interests, then it's a question as to whether you should follow that or not, because that would be against this particular rule here, and particularly if it's going to be against the due administration of justice, then it's even a worse situation. There's also those other rules that Christine was mentioning, which are in 17, 19 and 21, and these ones relate to advocacy of a solicitor, but they really are very similar to the barristers' ones, which I thought we'll have a look at now. But if we want to talk about the barristers' ones, just for the minute, you can see here once again, barrister is a specialist advocate in the administration of justice. They have to act honestly, fairly, skillfully, with competence and diligence. So that those provisions in the Barrister's Rule number 5 are really capturing similar sorts of things that are in the Solicitor's Rule number 4. But look at this one. Barristers should exercise their forensic judgments and give their advice independently and for the proper administration of justice, notwithstanding any contrary desires of their clients. So that's saying really in those situations where in their forensic judgment and in the proper administration of justice, that what their client is instructing them to do is going to be against that, then they don't have to follow the client's instructions. We've got other rules here that are again similar to the solicitor's rules that, a barrister must promote and fearlessly and by all proper and lawful means the client's best interests to their best of skill and ability. Okay, so you can see how some of these rules can actually conflict with each other. Barrister in the 39, the barrister must seek to assist the client to understand the issues in the case, their rights and obligations, so that the client can give proper instructions. Okay, so the client basically has to be properly informed so that they can give proper instructions. Here's this one about the barrister not being the mouthpiece of the client or the instructing solicitor and must exercise forensic judgments. They do that independently. After appropriate consideration of the client's and the instructing solicitor's wishes where practicable. It doesn't mean they have to follow what the client or the instructing solicitor is telling them. You'd have to be, the reality is, in most cases, they're going to follow the instructions of the client and the instructing solicitor. But there could be rare cases where they're not going to do that. You can see here at 42, the barrister will not have breached the barrister's duty to the client and will not have failed to give appropriate consideration of the client's or the instructing solicitor's wishes simply by choosing contrary to those wishes, in other words, acting in a way contrary to the instructions of the client and the solicitor, to exercise forensic judgment during a case and here are some examples, so as to confine any hearing to those issues which the barrister thinks are real issues, present the case quickly and simply and consistently with a robust advancement or the case's advancement, or inform the court of any persuasive authority against the client's case. So in this sort of situation, the barrister could well have properly made those decisions which they did in the particular case, even though they were against the client's instructions. So there's a few arguments there for and against. So for, you could argue, you're the specialist practitioner, you've got knowledge and experience, and you're exercising your forensic judgment based on the facts available at the time. Against, you're going against your clients, potentially as instructing solicitors' interests, and that there was a miscarriage of justice. But that's in hindsight. At the time, that didn't appear to be so. But in the subsequent case, because there was an appeal and the earlier judgment was overturned, then it's perceived as a miscarriage of justice at that point in time. But when you were dealing with it earlier, it wasn't. So you can see there, I've also included some quotes from some cases as well. You can see here the general proposition that as a general rule, a party is bound by the conduct of his or her counsel. Counsel have a wide discretion in the manner in which proceedings are conducted. Decisions as to what witnesses to call, what questions to ask or not ask, what lines of argument to pursue, what points to abandon, are all matters within the discretion of counsel and frequently involve difficult problems of judgment, including judgment as to tactics. And these decisions can be made while you're on your feet, standing there arguing these things. So this is why they give protection to barristers in terms of negligence, because there is there's a fairly great risk, given that you're doing a lot of this on your feet in open court in an adversarial, tense environment, that you can make errors. If barristers were completely liable and negligent for everything they did, professional indemnity insurance for barristers would be so expensive no one would be able to afford it. So there is a protection, as we'll see later, for advocates. The authorities concerning the rights and duties of counsel are replete with emphatic statements which stress both the independent role of the barrister and the binding consequences of the client of decisions taken by the barrister in the course of running a case. And I've given you some quotes there. Okay, so the bottom line is that in our scenario here, who has control effectively? In this case, really it's the barrister, isn't it? They have the control of how the thing is being run, how the litigation is being run. But they do have to exercise a forensic judgment within the limits of the rule, but they still have a lot more control than the client does. So in terms of what were the arguments for and against your actions, well, you would rely, in terms of for, you would rely on the rules which give you the power to make the decisions that you have done. The argument against is really largely in hindsight that, it was subsequently determined to be a miscarriage of justice. That's hard to, and that it violated the client's interest at the time. But that miscarriage of justice, you can't necessarily see that because an appeal decision may have gone the other way and it wouldn't have been a miscarriage. But I think the main thing to get out of this problem is what the duties are and where that those duties can conflict. The paramount duty is to the administration of justice, and that there's a lot of flexibility given to barristers and solicitor advocates in terms of how they run the case on behalf of the client. So that's the main points that come out of that. Did you have any questions about that particular problem?
You make it sound so easy, Stephen.
Oh, look, none of this stuff is easy. The only way you can answer it is that you've got to always go back to the rules and see what the rules say and see what the cases have to say. A lot of these things aren't clear-cut. So it might sound easy, but it really isn't. If you're standing there on your feet in court arguing something, you can do all your preparation and, things can happen when you have to make snap decisions about how you're going to respond to them. And, you're relying on your general knowledge. You can't sort of every instance say, oh, excuse me, Your Honour, I want an adjournment, and run up to the library and look it up. You're just not going to get away. You're not going to get away with that sort of stuff. So, yeah, it's a fairly tough environment being a barrister. So no, it isn't easy. So if I make it seem that way, I probably should stop doing that because it isn't. Okay. All right. Let's move on to the next question. Somebody's decided to print something in the background. Okay. Problem 31. Jane Jones is a bank manager who loves nude sunbaking. You are her solicitor. Last month, she and a couple of her friends were arrested and charged pursuant to Section 5 of the Summary Offences Act 1988, New South Wales, with the obscene exposure for nude bathing on a public beach. Jane was wearing a hat at the time. Well, that wasn't enough. You were advised that she may be able to win the case on a technicality. That is, she was not completely nude. You feel that there was a 40 to 50% chance that the magistrate will accept the argument. Jane feels that she has done nothing wrong and is not really guilty of anything. She feels a sense of outrage that what she was doing in all innocence may result in a criminal conviction with a large fine. Thus, she feels strongly that she should fight the charge. You warn her about legal costs, saying that you will have to brief counsel and that the total legal cost would be about $20,000. So, these are not insignificant amounts. On the other hand, you point out that if she pleads guilty, she can make a deal with the police prosecutor to have the charge come under Section 10 of the Crime Sentencing Procedures Act 1990, New South Wales, and that given her otherwise good character and plea of guilty, the charge is likely to be diminished to a Section 10(1)(a), which is really not recorded, or otherwise she will be discharged pursuant to 10(1)(b), with no fine on a bond for good behaviour for not more than 2 years, and then the charge will be struck from the record. She would be required to stop nude sunbathing on public beaches. This result will alleviate her concerns that if she fights the case, it may affect her position at work, although such a minor conviction would not result in a loss of her job. Would affect her image in the banking community. She knows that if she does not fight the charge, her days of nude sunbaking are over, and you need to make some money, so you support Jane's view that she has done nothing wrong and that she should plead not guilty. That last bit's a bit problematic, isn't it, about your making money out of the situation, but anyway. In relation to this problem, consider the following. What if Jane decides to plead not guilty and loses the case? Can she argue that you interfered with her independence regarding how she was to plead? What if she pleads guilty after listening to all your reasons, but in her heart knows she is innocent? Have you acted unethically? Okay, all right. Well, there's the scenario. So how are you going to deal with this one? What do you think? We're all gone quiet again. Okay, Margaret.
I just thought, reading through it, the first thing where he was talking about the wearing of a hat, that was quite frivolous. And
Yeah.
I really thought, well, there was really no need for that. But again, she has been given advice about what her options could be, whether she pleads guilty or not guilty. So I think in that the solicitor has abided by the solicitor's conduct rules. That last part about wanting to make money out of it, again, that would be, to me, unethical, putting that in there.
Mm-hmm.
But I think on the face of the advice that's been given, I really think the solicitor has acted properly in the advice that has been given to her. I mean, it was an offence. It's an offence to do this sunbaking on the public beach. There's no getting away from that. Yeah.
All right. No, that sounds good. Luke, do you agree?
Yeah, I do agree. There's both the for and against it. If you plead guilty, these are the penalties that may be imposed. She's still got it in her head, look, I want to plead not guilty. It's going to have some effect on me. I still want to be able to do it. On the byline to that, I suppose, is, yeah, I want to make some money. But I still have complied with those rules of again, get those instructions in writing. Yeah, you're going to press on, and well, from the scenario, we know you lose. So I still think there's it's okay to do what she's done.
Okay. What about you, Louise? Do you agree as well?
Yeah, I agree. I think that, at the end of the day, the client has, can either plead guilty or not guilty, and all you can do is give the client the advice that's in their best interest. I still think that, she's committed an offence, and I think it would, there's advantages of a guilty plea, which is in saving the court time and money. And I just think, because based on the facts and the offence, I think that, yeah, I don't know.
All right. Well, let's go through the suggested answer I've got here, as to I think how you'd set this out. I mean, these are all past exam questions, by the way. All of these things. That one came out of McFarlane's book, but I know that was an exam question set many years ago at QUT when I was there. So you'd set it out like this. Always go back to the rules. So again, you back to these basic rules: paramount duty to the court, administration, justice. Rule 3, Rule 4 again: best interest of the client, competent, diligent, avoiding compromising your integrity and professional independence. That one there is an issue about this notion of making money, because in one sense, it might be a compromise to your integrity, in the sense that if you're only advising them in a certain way in order for you to make money out of it, then that's really not, you're compromising, giving them full, frank and independent advice, because you're doing it for another reason. So that's something to bear in mind in relation to that particular rule. But in relation to Rule 12 in particular, you can see there, a solicitor must not act for a client where there is a conflict between the duty to serve the best interests of a client and the interests of a solicitor or an associate of the solicitor, as except permitted by this rule. Now, you could argue that if they're only advising them in a certain way because they're going to make a monetary benefit out of it, that it's a potential conflict with this rule. Okay. So that's on the one side of it. I've also set out all of those advocacy rules which were applicable to the previous questions as well. So I think the problem with the advice is that it could fall foul of this Rule 12.1 in that it could be based on a conflict of interest. So that's why I've said here, the fact that you base your advice on the need to make some money is problematic. That's a direct conflict of interest with this particular Rule 12. So that's what I would be saying there. In terms of advising, even if that wasn't your motivation, you would still have to go through all of the steps of creating a costs agreement, advising them of the likelihood of success and the outcomes of, or what would happen if they plead guilty, what would happen if they plead not guilty, and what the chances of success are. I think the problem here is that the advice that you're given is being tainted by the prospect of making some money out of it. This second part of the question, what if she pleads guilty after listening to all of your reasons, but in her heart knows she's innocent? Have you acted unethically? The answer would be no, because you would have given her, you've actually pointed out, as I said there, all the pros and cons of the position, and she's made an informed choice. And that's really where you want to be. You want to give unbiased advice as to the potential outcomes of all of the scenarios. And there's a passage there from Dal Pont's book, which is really good. And it says here, before entering a guilty plea for a client who maintains his or her innocence, the lawyer should seek to ascertain the reasons for the client's decision to ensure that it is not for irrational reasons or a misconception as to the possible outcome of the proceedings. The client should be advised on the strength of the prosecution's case, the prospects of acquittal, be fully appraised of the consequences of a guilty plea. The latter include that the plea is an admission of the elements of the offence, so that submissions in mitigation can be advanced only on the basis that the client is guilty. Client should be informed of likely penalty, criminal compensation orders that could follow, and any possibility that the plea will affect a civil liability claim. The advice should be supplied in writing, and the client's instructions received in writing. Otherwise, the lawyer may be at the mercy of the client, who repents from his or her decision and then, either then employs other solicitors and commences an action for breach of contract or negligence against you, the original solicitor. So again, like all these other problems we've been looking at, you need to act in completely unbiased manner and set out all of the scenarios and likely outcomes, and make sure that you give those instructions in writing, that your client understands them, and that you then get written instructions from your client as to what to do. That's what you've got to look at here. I think what was interesting about this is that all three of you didn't really perceive that this issue of here, you need to make some money, so you support Jane's view that she has done nothing wrong and that she should plead not guilty. That's a problem. It's a problem because your motive is wrong. What you should be saying is not looking at the money side of it, because you're going to earn the money anyway. Let's face it, you're giving the advice. Your client can then make an informed decision about what they want to do. If you want to push a litigation sort of scenario to make more money, well, that is really unethical. And that's really the point of what this question was getting at. And it was interesting that all three of you didn't actually think it was a problem. But anyway, do you see where I'm coming from?
I did say it was unethical.
Okay, you did. That's true, Margaret. I'll say that, but you did say that.
If we pass ethics, we can't be solicitors. Is that right or not?
No. By the time you finish, you'll be very ethical and you won't have any problems. But look, these things are not easy. And the worst aspect of it is that when you're actually out in practice, these things can crop up at any time. So you have to be on your guard, and you really have to watch out for yourself and protect yourself all the time. Make sure that if there's any situations of conflicts or potential conflicts, that you get some advice and you think about what you're doing before you actually get yourself into trouble. And that's really, really important. So this situation here where this person is thinking, they're going to make some extra money out of it if they happen to lean a certain way and encourage a particular client, that's, potentially not the best advice for that client, because it's motivated by the wrong reason. It might be the correct advice in the circumstances, but it has a wrong motivation. You need to set out all the choices for the client, and so that they can make it a fully informed decision about which way to go. And really that's all that this is getting at. Okay, all right. Any questions about this week 7's work, communication and control? Are we all happy about that? Yep. All right. Maybe you could form a group of 3 if you haven't already done so, because you're all, you're all regulars on this forum. That'd be an easy way to form a group of 3 for your.
Margaret and I have already joined up with someone else. And
Stephen. Okay, you're a bit slow there, Louise, by the sound of it.
No, Christine and I have joined up with Nicole Cooper.
Okay, all right. So you're all set. So what'll happen is that I sent out an email today. I hope you should have got it by now. It's just so that if people send me an email just telling me who's in what group, so that I don't have a situation where we have some poor person who can't find a group. So I can fix that up for them.
I haven't received an email yet, but it comes through in dribs and drabs, so I'll wait and see.
Oh, okay, all right. Yeah, I just wondered because I did send it. I probably sent it this morning, but it can be slow. I don't know when they run their email program. I begin to think it must run overnight or something. But I did send it.
Early morning or late evening, I think.
Oh, okay, all right. Well, if you haven't got it tomorrow, Luke, if you wouldn't mind just sending me an email telling me, because if you haven't got it by tomorrow, there would be a problem. But
yeah, certainly.
Yeah, all I asked in it was if people could form into groups, and if once they'd formed into a group of 3, if they'd just let me know who's in the group and the student numbers, and then I can work out which person in each of the groups gets what instructions, because there's 3 different sets of instructions, basically. And I just need to make sure that the right people get the right instructions, or we'll have chaos. Okay, all right. Well, we might stop there if there's no other questions. I hope you have a good weekend, long weekend, and I'll see you next week.
Thanks, Stephen.
Okay, all right. Bye-bye.
Bye.